Let's go on the record. Oh, actually, I can do it. Let's go on the record on cause number DC 199162, Penny Gum versus Medtronic Inc. et al. It's on a motion for protection. Counsel, make your appearances.
Your Honor, this is Ben Martin on behalf of the plaintiff. The court has announced the cause number, and I believe that's what the court needed me to announce.
Great. All right. Who else is here with you?
Your Honor, I believe that Ms. Laura Baumann is here this morning as well. I believe that Ms. Ellen Presby is also here today, all representing the plaintiff. I will, if I could, inform the court that because of a scheduling issue that occurred, I'm a little bit double booked this morning, and it's come to my attention. If we could, Your Honor, I'm going to allow or let Ms. Baumann talk this morning and give our argument, and then at some point this morning, we'll, if I could, have the court's permission, respectively, step out, and I don't think the court will need my argument.
No problem. No problem.
Thank you much, Your Honor. I appreciate it.
And Your Honor,
right.
Daniel McDonald also for the plaintiff.
Anyone else? Anyone here for the defendant?
Yes, Your Honor. Walt Herring is here for the defendant, Medtronics, and also Joe Tomaselli and Rami Fakori are on the line for the Medtronic defendants as well.
Great. And we're here on a motion to compel and motion for protective order.
Yes, Your Honor.
Okay.
And Your Honor, just real briefly, Sid Murphy for Dr. Rax.
Okay.
I'll probably be the most quiet one here today.
Good. All right, let's get started.
Your Honor, this is Walt Herring. I think it'd be good if we started with the protective order issue, because that might control the motion to compel issue as well. So it seems logical to me to start with that one.
Okay.
Your Honor, this is. Hold on.
Whoa, what's going on there?
I'm not sure. This is Laura Baumann.
Ms.
Okay.
Baumann, if I could, Your Honor, I think that means that, Laura, you have your computer audio as well as your phone audio. That kind of ricochet I've gotten previously on my, when it's happened to me. And we can't hear you.
Yeah, try again. Are you there, Ms. Baumann?
I'm here. Can you hear me now?
Yeah, are you in the same room as Mr. Martin?
No.
No.
Okay. Yeah, there's something wrong with your audio, and he may be right. That could be it.
Oh,
Are you- Are you calling in and with your phone and your computer?
Yes.
Yeah, why don't you shut one of them off?
I think, yeah, Laura, mute your phone and then just start talking so we can see if we can hear you. A second ago, we couldn't hear you, and I think you turned the phone back on, and that's when it all happens. My suggestion would be mute your phone for a second, experiment with trying to speak with your computer audio and see if we can hear you. If we can't hear you, you're probably going to have to go dark on the video and stay on the phone. That, I think, or maybe completely go out of the Zoom and just talk on the phone.
Ms. Baumann, are you there? Well, there's a number of attorneys here for the plaintiffs. Can someone make an argument so we can move this forward?
Your Honor, Laura, I think you probably should turn off your computer and just get back. First of all, make sure you're not muted on your computer. And maybe that's why you haven't been able to be heard. I don't know if that's, just give us one minute, if you would, Your Honor, just 1 minute, because she's prepared to make this argument this morning more than I am.
Okay.
Laura, we can't hear you, so my suggestion is going to be that you go dark on the Zoom video, and that you simply make your argument by phone and appear by phone. Can you do that?
Can you hear me now?
Yes.
Hello?
Yes,
Hello?
we can hear you. We can hear you.
Okay, great. Good. And Judge, I apologize for that. So let me start. And I agree with defense counsel that discussing the protective order first makes sense. But even before we get there, I want to do the easiest thing before the court first. And that is on Friday, August 14th, this past Friday, the plaintiff filed an agreed modified level 3 scheduling order. I believe all counsel for counsel for the doctor, for Medtronic, and for plaintiffs are all agreed on that modification to our scheduling order. And so we would ask the court to enter that order.
Let me just see. Doesn't look like we received that. When did y'all send it in?
It was filed electronically on Friday, August 14th.
Yeah, I'm not disagreeing with you. Just I'm looking what's on the system, and it's not on the system yet. But yeah, so when are you guys wanting to reschedule this to?
Your Honor, we basically pushed all deadlines by approximately 6 months. Are you asking me when the trial date would be?
It looks like we've actually rescheduled. It's already set for June 8th, 2021. So you're not trying to move it back from that, I assume.
Let me find the scheduling order. I'm not sure if we were aware of that. Daniel, can you help me out here? What's our new trial date?
If you look at the share screen, that gives you the date, I believe. Let me make sure I'm on the right case. Let's see. This was sent back. Let me see. Okay, yeah, we sent this to you October 17, 2019. So this isn't a new trial setting, but it is set for June 8, 2021.
Right, so the new, the postponed trial date would be November 1st, 2021.
Why are y'all moving it back? I mean, that's still almost a year from now.
Your Honor, it's related. I think it's related to two things. One, COVID-related issues have delayed our work on this case, but maybe probably more importantly and related to COVID and whatnot is we have only been, so far we only have been able to review the documents produced by Medtronic that have not been stamped confidential. So because of this protective order issue, which has been being kicked back and forth between the parties for months, we don't have any of the documents yet. We believe the document production is going to be voluminous. We're not sure at this point how many depositions we'll need to take, and that's in part also related to our motion to compel. There has been related litigation around the country with respect to these products for years. And there are deposition transcripts and trial transcripts that exist. And if we were able to get those, which is one of our requests for production, that might speed things up. But that's one of the many issues before the court with respect to our motion to compel that Medtronic refuses to produce those. So if we have to start from
Let's
scratch.
deal with the scheduling order issue. I don't really see a basis for it at this point, but it's not
Your
even
Honor?
filed. It's not set for today. So let's deal with the other stuff first.
That's fine, Your Honor. The only problem is that fact discovery, I think under the current scheduling order, would end within the next couple of weeks. And that's obviously not going to work because the defendant hasn't even produced a single document stamped confidential in the case. So we're going to have to do something about the scheduling order because as it presently stands, we can't meet those deadlines. But Your Honor, I'm happy to talk about the protective order. The parties have attempted to reach an agreement, but have not been successful in doing so. Really, I think what's tripped us up is frankly the Texas Rule of Civil Procedure 76A, which, as the court knows, is very strict in terms of what can be sealed. And so when we were thinking about this protective order issue, the defendant has wanted, for example, to put the burden on plaintiff to move for unsealing of documents that they, or move for non-confidentiality designations for documents that they label as confidential, but that's not really consistent with Texas law. And after our various meet and confers, what the plaintiffs have proposed and what we've filed in terms of our motion for protective order is that the court enter an order that has been used in the past in the 192nd Judicial District Court by Judge Smith. And we're asking for that because it just seems very simple and easy, and it's already been used in Dallas County. I think there are really only two issues that the defendant has objected to that I'm aware of with respect to this very simple, easy protective order. One of which is that they continue to believe that it should be the plaintiff's burden to move to de-designate documents that Medtronic designates as confidential. But of course, under Rule 76A, it's the defendant's burden to prove that those documents should be sealed or should be confidential. And this requires notice and a public hearing. It's a pretty serious burden. And it makes no sense to put the burden on the plaintiff to move to keep documents sealed that we don't even think ought to be sealed. We don't agree with the confidentiality designation. We didn't make the confidentiality designation. So under Judge Smith's order that we're asking you to enter here, it would be once we notify defendants of documents that we believe in good faith should not be stamped confidential, it would be Medtronic's burden, if they believe that those documents should remain confidential, to file the motion to seal with the court. And Medtronic has argued that this places some sort of incentive on plaintiff's counsel to over-designate, but that's certainly not our intention. And of course, if we over-designate, Medtronic could always raise that with the court. Really, what we think happens here will happen here, although we haven't seen their confidential documents. But what's happened, routinely is it's the defendants that tend to over-designate. And so under this scenario, it makes a simple and easy process for us to get those documents out from under a confidentiality designation when it's appropriate. And our order is consistent with Texas law and Rule 76A. The second issue defendants have raised is they don't like the fact that Judge Smith's order includes allowing among the folks who are allowed to see the confidential documents would be attorneys in other cases who have similar cases filed against Medtronic. Frankly, really, as we've told, that's the language used in Judge Smith's order. So when we moved for our protective order, we just stuck with exactly what Judge Smith has used. Really, as we've told Medtronic, what we're concerned about is our firm and Ms. Presby's firm, who's my co-counsel, have multiple cases filed in various jurisdictions against Medtronic regarding these devices. And we want to be able to use the documents across the cases and don't want to have to, for example, somehow maintain multiple databases and have multiple same document in multiple databases. It's not efficient. And we also don't want to have to conduct duplicative discovery. So once we have certain documents, we wouldn't have to ask for them again, you know, in 20 other cases. So we're really not looking to share documents with plaintiff lawyers in other cases. It's just that we want to be able to use documents that we are produced here in other cases rather than seeking them over and over again. So we think that we asked the court to enter that order. It's been used before in Dallas, and it's simple, easy, and it will allow us to finally get started on reviewing Medtronic's documents.
Judge, you're on mute.
May I respond, Your Honor?
I've actually used that order before, the Judge Smith's order, in other cases, so I'm familiar with it. Why wouldn't I use it in this case, I guess? Is there something unique about it?
Not
Well, Your
that I'm
Honor,
aware of. I'm sorry. Go ahead.
Can I respond, Your Honor?
Sure.
So first, we sent a proposed discovery order to the plaintiff's counsel in January of 2020. January of 2020. Did not hear a word from them on that scheduling order. We sent it again in May. Protective order, excuse me, a protective order in January of 2020. Didn't hear from them for months. Sent it to them again in May. Said, we have 10,000 pages of documents to give y'all. We just need this protective order signed, because a lot of these are, even the plaintiff admits, a lot of these are protected documents under the FDA. They're protected documents. They are not publicly disclosable, but we will provide them, but we need a protective order in place. We want to give them to you. They're here. Let's get this order done. We didn't get a comment from the plaintiff's counsel on the protective order that we sent in January until July 2nd. That's the first time they responded to us with comments on our protective order. At that time, they gave some comments. We had some brief discussions. We made some changes that they requested. We got an email on July 14th, I think, saying, we agree. July 16th, we agree. About 5 minutes later, we got an email back from the same lawyer saying, oh, we don't agree. We need to do something else. 2 days later, we got a completely new proposed protective order. This one, after we thought we had negotiated one, even though it took 6 months to get back to us. The new protective order, which is that Judge Smith's order, the one we think has some concerns. We tried to negotiate that for a few days. And then a week later, we got this motion to enter this protective order. So our two concerns with the Judge Smith's order are, accurately said by Ms. Bowman, is that the burden issue and the sharing with other counsel issue. On the burden issue, I think Ms. Bowman misrepresented our position. It's our burden to show that it's a confidential document. Our question, though, was who has to raise that with the court? If we label a document confidential and they come to us and say, we don't think that's confidential, we would have a discussion. And if we couldn't agree, then they can bring it to the court's attention. And then it's our burden at that time to show that it is confidential. But we believe they should be the ones to bring it to the court's attention, because as we all know, as we have just said, many of these documents are clearly going to be confidential. We're not going to over designate. We think we have an opportunity to discuss at the time where, once we've designated, if they think something is confidential, we might change our mind and say, okay, we'll de-designate that. But they should have the burden to at least bring it forward initially, and it's our burden to show that it's confidential. That's the first issue. The second issue on allowing counsel to look at other documents, or look at documents in other cases, our documents in this case, in other cases. The other cases are in other jurisdictions that have different laws, that have different confidentiality issues, that might have different, burdens and discovery issues. For instance, one of them is in Georgia. We don't think it's proper for this court to allow what's discoverable in Texas to be automatically used in Georgia. They need to go to Georgia and convince that judge that under Georgia law, that document is discoverable and producible. We don't think that's that difficult of a burden to do. And we all have different databases in these days. Keeping a database for a particular case is not that difficult, truly not. So we do think that it's improper for them to use a document that we've produced here for it might be the same pump, Medtronic's pump, but it's going to be a different doctor, a different medicine, a different catheter, different other products used, different other physicians.
So are any of these documents specific to Ms. Gum, or are they documents that are just general company documents?
Well, as an example, they've asked for every document related to this pump since its inception in 1986. So they've asked for every document related to this pump for the last, what is that? Doing math in my head, 36 years. So most of them aren't, many of them are about the development of the product, about the manufacturing of the product, et cetera, that aren't.
Okay, but okay, I don't know if my question was clear. What are any of these documents related specifically to Ms. Gum, or are they general company documents?
Well, some of them will be. Some of them will be related specifically to Ms. Gum,
Okay.
and some will be related to the overall product itself.
So what kind of documents are they requested related specifically to Ms. Gum?
Oh, the particular testing for this particular pump that was used with Ms. Gum.
They did testing on that exact one that she used?
Yes, they have. And the plaintiff's counsel was there for that test. That pump was tested.
I mean, I've used this order before. I've never really had an issue with it. I don't remember really. I think a lot of these are kind of more theoretical issues that dealing with national products liability arguments. They haven't really been an issue in any cases. So I don't have a problem with entering Judge Smith's order again. I don't see this case as any different. I am a little concerned if there's any documents related specifically to Ms. Gum that would be used in another court. And so I guess to the extent that there's any document specifically about Ms. Gum where her name is specifically mentioned in the document, then I wouldn't want that to be used in another court. But any other documents, I don't see a problem with that. So with that one exception, I'll go ahead and enter the motion protection requested by the plaintiff. Do we also have a motion to compel that's set for today?
Yes, Your Honor. We filed a motion to compel with respect.
Just one second. Your Honor, after that, I'm going to go ahead and step out. I appreciate the court's time today. Thank you very much.
Okay.
I might suggest, Your Honor, that they get these 10,000 documents before we have a motion to compel.
Your Honor, if I could be heard first, since it's our motion, I'd appreciate it, but it's a.
Okay.
What defense counsel was just raising, it seems to be their response, primary response to our motion. On May 7th of this year, we sent Medtronic a very lengthy, detailed letter documenting all of the deficiencies or all the problems that we had with their responses to our request for production. And in response to that letter, defendants only responded regarding two things. One is the protective order issue and one about privilege. So I'm going to talk about privilege first. But the rest, they didn't respond at all. And similarly, so when we filed the motion to try to get those objections or most of them overruled, so that when we get this production, we'll get the documents we're actually asking for, defendants emailed me right away and said that they felt that we hadn't had an adequate meet and confer. And so on July 28th, I responded by email to them and said, well, you've never responded to our letter on the substantive issues, but I said I was available that day and the next day at 5 o'clock for a phone call, and they never responded to that. So, and then what we see when they responded to the motion is they didn't actually address the issues that we've raised in a very detailed manner in our motion, raised similar to the letter. So
I want to make sure I'm clear on this. So you guys have never met and conferred?
we sent a letter detailing every issue that we had, and they never responded to that other than to say what they're doing right now. Well, you know, we're not going to give you any documents until there's a protective order, and we have privilege. We're asserting a privilege, and that's it. And they didn't respond to us. And so then we filed the motion, and they reached out to me. I said, okay, let's talk on these 2 dates, and they didn't respond to me. And then in the motion, they didn't address our issues. So that's where we're at on it.
So you have not met and conferred?
Not orally, only in writing.
Okay. So let me kind of give you a big picture here of what my concern is about this is that, as you guys all know, we're in the middle of a pandemic. We have not been able to have jury trials, but this court has been working extremely hard on hearings, bench trials, everything we can do besides jury trials, which we're in a moratorium for. And so what I foresee is going to happen is that we're going to, the good thing about this time that we're in right now is that I've had more time for hearings. I have more time for bench trials. I'm trying to get as many of those issues worked out as possible, because once jury trials resume, and I have no idea when that's going to be, we're going to have, already have 6 months worth of backlog. It's going to be significantly longer than that in all likelihood. And so I have time to work these things out. And so my concern about the scheduling order and all these other issues is it seems like maybe that there's been kind of delays. I don't think it's because of the court. We're regularly scheduling hearings. We're actively pushing cases. We're doing everything possible, but things have to be done remotely. I mean, it's just not safe any other way. But the fortunate thing is we now have technology where you can take depositions remotely. You can deal with these issues remotely very effectively. You just have to learn the technology. And so that being said, what seems to need to happen is that, I kind of agree with the defense attorney, go ahead and produce these documents, orally confer on with the protective order that we discussed, orally confer on each of these. How many requests are we talking about?
Your Honor, there are 29 requests where the defendant has responded in writing to our request saying, we are not going to give you what you want. We're going to narrow your request to what we think you should get. And I understand what you're saying, Your Honor, but I'm afraid if we go down the route that you're suggesting, it will just cause more delay in us getting to the point where we're ready to take depositions and whatnot. If I could give you 1 or 2 examples to show you what I'm talking about, that might be helpful.
Your Honor, this is Joe Tomaselli. If I can just jump in here real fast. We completely agree with you, Your Honor. If you go back to some of the things they want, the first thing in their list is PMA specifications related to that product. That's absolutely something that we're prepared to produce. But as Mr. Herring, my co-counsel, said, it's unquestionably confidential. I mean, if all this stuff is out there in the public, somebody else can just figure out how to make this pump and make this product, and it's clearly trade secret. So we want to produce that stuff. We want to give them all that stuff. However, we have said we will not give you every single document related to this product. And that's currently what they want. Every single document for 36 years. This case is about a manufacturing defect, and that's it. We have tested the pump. We have tested Ms. Gumb's pump. We did that a year ago in their presence. We have given them all that information, and it's tested no anomaly whatsoever. So again, we're happy to give them the specifications of the products. We want to give them the specifications of the products. We want to give them our annual reports to the FDA that talk about all the different submissions we have over the years, both in terms of supplements and others. We want to give them all that, but we will have to come back in front of you if they continue to want every single document for 36 years. It's just not proportional to this case.
Your Honor, if I could respond, and I'll give you a couple of of examples of what we're dealing with.
All right, let me make it clear on kind of what we're going to do, and I don't mean to cut you off, but we can do this a couple of ways. We can. It seems like this will be more time consuming, but it concerns me that you two have not conferred at all. So I'm going to put you into a breakout room. I want you to confer about every one of these different requests. That may take you all day. I don't know how long this will take you. That may take you all day. When you're finished, I'll send one of my interns, Miss Ablon, into the room with you. She'll text me when you guys are done. I do have a lunch thing from noon to 1, but other than that, I'm just in hearings all day. Then you can come back and we can discuss each of the individual. So there's not going to be a delay, but you do need to, I'm not going to rule on all of these individually unless I absolutely have to. And that will probably take us just doing this a different day. But the good thing is, as I mentioned, I don't have jury trials. So I could meet, Wednesday probably, or Tuesday afternoon in all likelihood, and spend all afternoon with you and kind of work all this stuff out. But I'd rather you guys, as you're supposed to do, orally confer. And so I'm going to put you into a breakout room. You have until noon, then you'll have to take an hour break because Ms. Ablon has to leave as well. And then you'll return back to this link if you're not finished. And then I'll send you back to a breakout room. Why don't you return to this link if you're not finished by noon? Return back to this link at 1:30. I'll send you back to the breakout room with Ms. Ablon, and hopefully you guys can do all your conferring by the end of the day. All right, guys, I'm going to put you in a breakout room.
Thank you, Your Honor.
Judge, there's three lawyers for the Medtronics. It's Rami, Joe, and myself.
Rami, okay. So let me see. Mr. Herring. Let me make sure I have everyone's name who's going. Herring, Tomaselli. What is Rami's last name?
Fakhouri.
How do you spell it?
Fakhouuri.
And who's there for the plaintiff, Ms. Bauman? And who else?
I think Ellen Presby and Daniel McDonald.
And Ms. Ablon, go ahead and text me once you guys are finished. Okay, let me try to do this. Breakout room. There we go. Manually create rooms. Sign. Okay. Daniel McDonald is not involved in this case, correct?
Yes, he is.
No, he
Your Honor.
is.
He is.
He works
He is,
at
Your
my
Honor.
firm.
Oh, I'm sorry. You're right. Okay. Ms. Presby, Ms. Ablon, Mr. Tomaselli, Ms. Bauman, Mr. Fakhouri, Mr. Herring. Did I get everyone?
Your Honor, Sid Murphy. I don't think they need me in the breakout room, but could I ask, for example, Mr. Herring to call me when we come back? Because I've got
If you're on the case, I'm sending you to the breakout room. You can do whatever
enough.
you want at that point.
Thank you.
Anyone else here on this case? Okay, I'm sending to there, and Ms. Ablon, just text me when they're done. And you'll get an invitation. You need to accept the invitation.
Thanks, Your Honor.
Thank you, Your Honor.
Thank you. Okay, let's get back to work here. Is anyone here on the dismissal docket? Anyone here on the dismissal docket? We had some people who were late to the dismissal docket. Anyone here on the dismissal docket? Okay, let's go to NRA JG Wentworth Organization versus, or sorry, JG Wentworth Organization LLC.
Your Honor, Desmond Cooks on behalf of JG Wentworth.
Okay, anyone else here?
It should
I'm
be
here.
next. There we go.
Let me just see this, okay. All right, so did you guys submit all the information that's required by the standing order yet? I don't see it.
I have a copy of it, Your Honor. They should have filed it. I think I got it Friday.
I don't see it. Do you see it on here? Can you see the screen?
Give me one second.
Mr. McDonald, do you need to be sent back to the breakout room? Did you get knocked out or something?
Yes, please, sir. I joined on a different device.
Let me see what I can do. I've never done this before, so I hope I can assign you to a breakout room again. Let me see.
If it's a hassle, Your Honor, I
Okay,
can just
let
go
me.
back to my old
I
device.
think I just sent you an invitation. Did you get it, Mr. McDonald? Okay, I guess he accepted it. Okay. Do you see it here? I don't see it. So is it? Am I missing it somewhere?
No, I didn't see it on that screen.
Okay.
Is there a way I can email it to your clerk?
Rhonda, are you there? I don't know. Yeah, you'll have to call Rhonda.
Okay.
Yeah, go ahead and call Rhonda, and you guys can work it out and then rejoin the call.
Okay, sounds good.
All right, thank you.
Thank you, Judge.
Is anyone here on Gonzalez versus Securitas Security Systems USA?
Yes, good morning, Your Honor. Plaintiff's counsel Lena Lorenzo is here, and I believe I can see defense counsel as well. Good morning.
Yes, sir. Good morning.
Good morning, guys. How are you?
Good.
Doing well, Your Honor. Hope you're well.
Doing well. Okay, are you guys planning on moving forward with this motion for summary judgment?
Yes, Your Honor, it is plaintiff's motion.
All right, do you want a record for this? We're on YouTube right now, but do you want a record for this?
Sure, Your Honor.
You don't have to, we usually don't on summary judgments. But you
Yeah,
can.
I think we're fine with that, honestly, Your Honor.
Okay, go ahead.
Okay. Well, good morning, Your Honor. Hope you're doing well. Thank you for accommodating us on this safe Zoom hearing on plaintiff's no evidence motion for summary judgment on a slew of defendants' affirmative defenses. The matters before the court have been streamlined, meaning plaintiffs basically filed their motion, his motion attacking all of the defendants pled affirmative defenses, and defendants did file an amended, first amended answer, dropping a lot of the non-applicable affirmative defenses. So we're focused here today primarily on contributory negligence by anyone, the plaintiff or any third party, any new and independent cause that's superseding for this incident and the damages involved, as well as Mr. Gonzalez, the plaintiff's injuries and damages that he has that they're alleged to be caused by either prior or subsequent matters. And so focusing primarily on defendant's response, they offered minimal evidence to support the specific elements that we challenged. Specifically, we challenged duty, breach, causation for contributory negligence for both the plaintiff, Mr. Gonzalez, as well as any other third party, as well as one deposition question and answer from the defendant, Mr. Leach, the driver who was driving defendant Securitas's vehicle. At the time of this incident, Mr. Gonzalez was a pedestrian at the time, and this is a turn that resulted in a pedestrian accident inside of the crosswalk where Mr. Gonzalez was. The one deposition answer from the defendant Leach is just simply him testifying that he believed he had the left green turn arrow and nothing more. as well as one deposition answer that doesn't truly support that answer. It's merely a response by the plaintiff that at the time he was struck by the vehicle inside the crosswalk, almost completely across, he did not know the driver, Leach, Mr. Leach's light at the time he was struck. And the defendants also included plaintiff's expert report, Dr. Sasha Iverson, who is a board certified life care planner doing rehabilitation medicine. And so they also defendants mentioned plaintiff's discovery responses and document production, but none of that was attached to their response or to their SIR reply. And so we are limited with very small amount of evidence. You can see that the defendants attached the police report. The plaintiffs have objected to that police report as inadmissible evidence. It's hearsay within hearsay. No testimony from the investigating officer was offered to provide any sort of foundation or context for that police report. And so essentially, we believe that the plaintiffs are entitled to summary judgment on defendant's allegation of contributory negligence against any third party. There is no third party that has been identified in discovery. They did not point to anyone in their response, nor did they offer any evidence of any third party that is remotely involved in causing either this incident or plaintiff's damages. And so we believe that we're entitled to summary judgment on that affirmative defense. Defendants provided no evidence at all regarding any new and independent cause of this incident or Mr. Gonzalez's damages. There's also no evidence provided on by defendants on anything regarding Mr. Gonzalez's injuries and damages being caused by prior or subsequent matters, accidents, items, things like that. And any sort of argument that defendants would have wanted to do about causation of this incident, especially with regard to Mr. Gonzalez's medical conditions, they needed an expert to do that, to have some sort of competent evidence to actually raise the level of having more of a scintillant evidence to tie any sort of other event in Mr. Gonzalez's life before or after this particular pedestrian motor vehicle collision to have caused his injuries and damages that he's claiming inside of this case. Now, I'm not sure. I'm sure Your Honor has read through the pleadings, and so I don't want it to be overly
Let
repetitive.
me just hear the response. Let me see what
Yes,
they
Your Honor.
have to say.
Okay, are you finished, Lena?
Sure. I may have more, but please go ahead.
Okay, Your Honor. First, I'll address the contributory negligence, and note that their motion is a no evidence motion for summary judgment, and their claim is there's no evidence. Yet they respond with evidence to counteract our evidence. Obviously, there's two versions of events. That's the whole point. That's what we have here is two versions of events, and that's what we presented to the court. Mr. Gonzalez, the pedestrian, had a duty to cross when it was safe to cross, and we affirmed that he did not cross when it was safe to cross. We have testimony from the driver that says he had the green light, which would indicate that it was not safe for Mr. Gonzalez to cross because he would not have had a walk indication. The plaintiff says he doesn't know if Mr. Leach had the green light, so we have conflicting evidence there. It's why we didn't file a ton of evidence, because it's simple. It's a said she said kind of argument. And if Mr. Gonzalez, the plaintiff, he had a duty to cross when safe, and if he didn't do that, then he violated that duty and caused the accident. As for the police report, we don't know what they're saying is hearsay. The actual, you're supposed to be specific when you object to specific elements within the document, and they haven't done so. All we know is that this police officer testified that his report was accurate, that he didn't redact anything from his report. And the report notes that the plaintiff had been drinking that day and had alcohol in his system. We're not putting the officer up as an expert saying that he has commented on the plaintiff's intoxication, whether he was or wasn't. That's for the jury to determine if Mr. Gonzalez's actions in light of the drinks that he'd had violated his duty to keep himself safe and others. And we think that the evidence is there to show that. their claim, Miss Lorenzo, is to come back with other evidence and say, no, our evidence says it's this. Well, that's the thing we've got here, is we've got conflicting evidence. So on contributory negligence, on a simple no evidence motion for summary judgment, I think we've shown plenty.
The summary judgment on contributory negligence or comparative fault, or however you want to call it, comparative responsibility, is denied.
Okay. The second issue is the causation of their damages, and it's simple to the extent that Mr. Gonzalez was struck by the vehicle. He sustained certain injuries to his body. He received treatment for those, and that is not what we're saying. It's some pre-existing injury. He then got a life care planner. The life care planner, who's an expert, not a treating physician, says he now has a neurological injury, has a brain injury. Mr. Gonzalez has testified that he had a prior accident where he did get a brain injury and has suffered from seizures from that brain injury and before the accident. What we've got now is a life care planner saying that this brain injury that he got from this accident is causing him to have issues at work. This is all new. We have no evidence that this was actually a thing because he'd never produced it in discovery. We then sent discovery to plaintiff asking for what issues he now has at work. He's doing the same job he was doing before the accident. So we need to know what now is it that you cannot do because of the accident that you could do before. We got answers back last week that say plaintiff will supplement. So that's all we're focusing on, is what is the difference between before the accident and after. And we know that you had a brain injury before. The jury can look at you before the accident and look at you after the accident and make a determination. So again, it's just the fact that he said he had a brain injury before, and he now has an expert who has said he has one at this time as well. We need to know to what extent that is, and we're working to get more information on that, but we have enough to get past no evidence summary judgment when he said he had a prior brain injury that caused him to have seizures and other issues.
If I may respond briefly.
Summary judgment on causation is denied. What's the next one?
Those are the only two that that I think still were there. Everything else we had amended our answer. We're only arguing comparative fault to the plaintiff and the causation issue.
Is that correct?
Yes, Your Honor. Those are the two primary issues at this time.
And let me just say this, I did personal injury law. I was a plaintiff's lawyer before I went to the bench, and I handle these car accident cases pretty consistently, which I'm also board certified in personal injury law. Almost always, issues of negligence and causation are going to be a fact issue. So, Mr. Hartman, I've seen situations, I'm not saying you would do this, where attorneys in this situation will have, now I won this summary judgment, now I'm going to file my own summary judgment. And I think this is just all a fact issue that the jury needs to decide. And so I can't prevent you from filing it, but don't take from my denials that somehow I think that there's no fact issue on your side either. I think it's a fact issue that needs to be decided by the jury.
Yeah, Your Honor, I haven't filed a summary judgment motion in a negligence case in a very long time for that.
Yeah, the only time that anyone ever wins those is if they're not responded to. So yeah. At least in my court. So anything else, guys?
No, Your Honor, that's it.
We appreciate it.
All right, guys, you be safe out there, okay?
Thank you for your time, Your Honor.
All right, I'll go ahead and get an order on this today.
Thank you.
Thank you.
Thank you. All right, Mr. Lipman, what are you here for?
Yes, Your Honor. Sorry, I apologize when you called. I guess my mic was on mute. Hopefully you can hear me now.
Yeah, what are you here for?
I'm on these 4 Unifund CCR dismissals.
Okay.
Three of them are fine to just dismiss. We could not get service. One, I have verified property ownership, so I wanted to see if I could file.
Sure. Which one do you want to keep?
The one that I was hoping to keep was Corey Blair.
What cause number is that one?
That is DC-19-19481.
All right, so keep that one. How much time do you need on that one?
Probably 30 days. If I'm going to file a motion with the court and see if we can get that served, or file maybe a motion for alternative service. I have the proof of the property ownership. And so I was hoping to submit something to the court showing the defendant owns the property. We've tried multiple times and been unsuccessful getting a service.
Rhonda, I hope you're still there. So the first three unifund cases, DC 1919254, DC 1919260, and DC 1919264, or I think it's the one that's at 60 and 64. All three of those need to be dismissed. The fourth one, we'll go ahead and give them 30 days. Is there anything else, Mr. Lippman?
No, thank you, Your Honor.
Thank you. Sorry to keep you waiting so long.
Pop, my apologies. Thank you.
No problem.
May be excused. All right, thank you.
Okay, Mr. Cook, I think we did get,
Yes, sir. It just hadn't been accepted yet.
okay. All right, so I got the affidavit. It seems to cover everything. So I'm a little unclear here. So she has a job and she's going to school as well. Is that right?
That's what I'm gathering, Your Honor. I don't know.
Is she still here or no? She's not here. I don't. Okay. Oh, there's some more people here. Okay. Okay. Mr. Scott, what are you here for? Mr. Scott, are you here?
I am here, Judge. Good morning.
What are you here for?
I think it was a scheduling order. Status report.
At 10 o'clock. Okay.
I think we
Judge. Yeah, I saw that. The other side's not here yet. We'll give them a few minutes. Okay, let me just deal with this one then. So, Mr. Cook, Ms. Lacey, I'm looking at your affidavit. So she has a full-time job, it looks like, right? Is that correct, Ms. Lacey?
Yes.
And are you going to school right now, or what is your situation? It's not clear here.
After this meeting, I actually have an interview with one of my colleges to get my tuition together and stuff.
So you're not in school right now?
No, not yet.
And what's okay? So what are you using this money for? You're not even in school, right?
Yes, but I'm going to school once I have my stuff together.
Okay. And how much is tuition at the school?
I'm not sure. That's what the meeting is for after I'm done with the court.
And have you applied for, so you haven't, okay, wow. So usually when we're in this situation, there's someone's currently in school, but you're not even in school right now. And so we don't know what the tuition is. We don't know, what are you gonna, which school is it?
It's Pallington in Arlington.
What's it called?
Pallington College in Arlington.
I've never heard of that. How do you spell that?
It's Pallagton, and it's in Arlington.
Pallagton. Let me look it up. I've never heard of that school.
I'm not sure if I spelled it correctly.
There isn't anything on the internet with that.
It's a nursing school in Arlington. It's a community college.
Okay. Is it part of Tarrant County Community College?
I'm not sure.
Okay. Because tuition at community college is usually very low. Yeah, so in-state tuition, you live in Tarrant County, correct?
I live in Kaufman County.
But you live in Texas.
Yes.
So tuition, I just looked it up for Tarrant County Community College, is only $3,402 a year. So it shouldn't cost you $37,500. I know that this is frustrating and it'd be easier for me to just approve these, trust me, because people are never happy with me, but I don't see any basis for this based on what I've got.
Is it, the amount, or is it something that you want her to just look at completely?
So what exactly is she giving away and what is?
You're selling $62,306.23, receiving $44,500.
And when do the payments start?
Put that out.
Trying to look it up here.
Yeah.
JG Wentworth and Peachtree pushed through that rule that says that we're not allowed to look at anything that's like it all supposed to be redacted, but now it's almost impossible to evaluate them.
Right. Give me 1 second, Judge. I have it up now. Payments began January 1st, 2021.
Oh, wow. Just a few months
Yeah.
from now.
Right. And that was for 8,900.
Okay, so where here? Let me share screen this because I can't find where the deal is in this. I think this is the agreement. So where? Yeah. So you guys even black out what the payments are. I can't approve this. I don't even know what the payments are.
Is it just, I think, do they email you a copy of an unredacted version? So I think on the system it's redacted and then they email the unredacted version.
I don't think the rules even require that. I think it's supposed to just redact her name, but as a judge, I have to be able to see this stuff, and you can see on the screen what we have. This is what we've got. It says it doesn't give me any information about who the seller is, what she gets, what the net amount to the seller is, whether or not she even signed it, what the purchase is. I mean,
right, but do they? So they don't give you a separate file with the unredacted versions?
if they did, I have what's on the system. I'm not at the courthouse, so.
Okay. How would you like us to start doing that in the future then?
I mean, I understand, I kind of not really understand why we have to redact the person's name. I think it's kind of ridiculous. And this even says the jurisdiction should be in the 167th Judicial District Court. I don't even know what that's about. That's not even in Dallas County.
Oh, so then typically then that's the court of origination, and then when they move, when the annuitant move, it gives them the ability to do it in their county.
Okay. But I mean, not having even the terms of the deal that I can see makes it almost impossible.
Right. Yeah,
Unless
so
I'm missing some, do you see it somewhere on the screen where the numbers are? Because I don't see the numbers.
no, so it's exactly what I just described. On the system, they're gonna always file the redacted version. And I think pre-COVID, I don't know how to do it in the climate that we live in now, but they would always file the redacted version and then send the court the unredacted version. So what you're looking at, if all of that's redacted, then there's probably, you won't see anything of relevance for that you would need to make the determination, because the relevant information would probably be redacted.
Can you pull up the law on this? I think this is way I thought it was just the name and the identifying information on the plaintiff. Is it also say you can't include the terms of the deal either?
Judge, it's one of those things, those legal things where everything's into the interpretation. And I think what they interpreted as identifying the annuitant includes some of the payment arrangements. I was speaking with my contact over there, and that's kind of their rationale, was they can still be identified by the payment arrangements. And so they believe that that was identifying information.
Well, I don't.
Right. I mean, it
Yeah.
goes to interpretation of.
I don't know what to tell you. I mean, there's nothing here that I can make a decision on. I'm open to suggestions, how you'd want to do this. You could follow, I guess, an amended one or something. I mean, I need to know what she's selling exactly, over what period of time. Are they guaranteed payments, non-guaranteed payments?
Okay.
I mean, there's nothing here.
I say, is there any other way to get you those documents?
Like, what are you suggesting?
Email, like I said, because I believe that's how they've done it, is file the redacted versions and email the clerk the unredacted versions, which has all that information on it.
Okay. Yeah, I mean, in the past, sometimes they do. I've never seen this much redaction. So this has not, I mean, usually it's the person's name, and I need to know to be able to, like, this doesn't even have, I guess it's because it's not originally on my court. It also usually has the original cause number to make sure I'm the right judge to hear it, but it seems like I would be here. But yeah, I guess you could, yeah, get that to me or something. But also, I don't know anything. I mean, I don't know the terms of the deal. I don't know the payments. I don't know the payout. I don't know how much the tuition is at the school. She doesn't even seem to have information about the name of the school, because there's nothing on the internet with this Pallington. Tuition at Tarrant County Community College is only $3,400, and she's asking for $37,000. I mean, there's just not a lot of information here. She has a full-time job, so in a place that, you know, as I understand it, this is just for tuition, basically. So there's just a lot of information out here.
Judge, are you giving us permission to reset, or are you going to deny it today?
Yeah, I'll deny it without prejudice to refile. Rhonda, go ahead and put this on a 30-day DWOP to give them time to submit more information. But Basically at this point, I just don't have enough information.
Understood.
All right, just give me the information, and not just this unredacted version, but just, I don't know anything about the college. I don't know how much the tuition is. That's, since she's her one basis, usually people who are selling annuities have had some type of life crisis. It's not usually this type of situation, and not even knowing the name of the school obviously is a big concern, or how much the tuition bill would be, or if she's been admitted, or anything really. I don't know that I would grant it, but I'd want to see more information.
Understood, yeah.
All right, sorry about that, guys.
No worries. Maybe excuse.
You may be excused.
Thanks a lot.
Mr. Scott, are you there?
So far, so good, Judge.
So who's your plaintiff's counsel on this one?
Somebody over at Scott Lidgey's office. I'm pretty young. I've never met him.
So when do you want to set this for trial?
Actually, I think we've agreed, and hopefully he got the date from your court coordinator, but we have it on our order for May 24th.
Oh, the date of the trial setting?
Yes, sir.
Let me look this up real quick. This is on Min Hinnett, is that
Yes.
right? Versus Irving Holdings?
Yes, sir.
Okay. Yeah, that's you guys. We do not have a trial setting on this case, or a scheduling order. So what did you say that you submitted? Oh, here it is. You guys just submitted it last week. Let me go ahead and print this out. May 24th of 2021. Is that what you wanted, Mr. Scott? Mr. Scott, are you there? Did he go away? Mr. Scott, are you there? Mr. Scott? Hello? Okay. I'll go ahead and sign the scheduling order, I guess. Okay. Let me turn off YouTube.